Good afternoon, ladies and gentlemen. Welcome to another edition of Democracy and the Rule of Law, a show where we delve deep into the critical issue of law, politics, and governance. In today's episode, we'll look at the issue concerning the recently Supreme Court judgment. It is not new that the Supreme Court has dispensed with almost all the governorship petitions that were filed before it. On Friday, the issues concerning Plateau, Kano, Lagos, Rivers, Enugu, Ebonyi, and so on were decided by the Supreme Court, which of course is the final court of the land. Of course, today we would take a special look at the decision concerning the Plateau State governorship election decision, which by extension affected the appeal court decision on the law about 20-something lawmakers, both the state and the federal lawmakers that were elected under the platform of People's Democratic Party, that were sacked by the appeal court based on the issues surrounding their nomination, which the Supreme Court has come to say that these issues had already been laid to rest, that pre-election matters should not be treated as a post-election matter, and therefore has declared the appeal court decision sitting in Abuja decision perverse. But the issue we'll be looking at today is what remedy would avail these lawmakers who had been sacked by the appeal court, given the fact that appeal court has the final decision on parliamentary elections. Moving forward, we'll also look at another issue which has generated a lot of buzz in the polity within the week: the relocation of some federal parastatals, especially the CBN. Some of the key sectors of the CBN were relocated from Abuja to Lagos, and also the headquarters of the Federal Airport Authority of Nigeria, which was also relocated from Abuja to Lagos. It had generated a lot of buzz, and a lot of persons have raised eyebrows and also called to question the constitutionality of relocating those federal institutions to Lagos. So we'll look at all of these things in today's episode. We have our guests already seated in the studio to help us dissect all of these issues. My name is Kenneth Wimo. We'll go on a very short break, and when we return, we'll introduce our guests who are already seated in the studio waiting to do justice to this topic. So stay tuned, we'll be back very shortly.
The appeals were fallout of the March 18 governorship election in Nigeria. After the determination of the matters by the Election Petition Tribunal and the appeal courts, appellants not satisfied with the outcome approached the Supreme Court for the final determination of their cases. The appeals which were laid to rest today were from Lagos, Bauchi, Kano, Zamfara, Ebonyi, Abia, Plateau, and Cross River states. For Lagos and Bauchi states, the Supreme Court dismissed the appeal by the Labour Party and the People's Democratic Party and upheld the election of Babajide Sanwo-Olu. Also, the Apex Court also upheld the victory of Governor Bala Mohammed of Bauchi states. For Kano State, the Supreme Court, in its unanimous judgment, allowed the appeal of Governor Abba Yusuf of the New Nigerian People's Party, while the court also upheld the election of Governor Dauda Lawal of Zamfara State.
Our respected Supreme Court justices have delivered their judgment and affirmed my election as the duly elected governor of Kano State. Today, alhamdulillah, not only me, not only my family, but all the good people of Kano State.
It's actually what I was expecting, so I believe the judiciary are doing very well, and Zamfara people are happy, and we're grateful. We'll now go back, settle down, and do the needful in terms of governance.
The 8-member panel dismissed the appeal filed by Chukwuma Odi of the People's Democratic Party from Ebonyi State, while it also resolved all 5 issues raised against the appellants. Also, in the appeal from Plateau State, the court set aside the judgment of the appeal court and upheld the judgment of the tribunal, which upheld the victory of Governor Caleb Mutswang. For Abia State, the Apex Court dismissed the appeal and upheld the judgment of the lower court. And for Cross River State, the court also upheld the election of Basi Otu as the governor of the state. Some of the councils lauded the dexterity of the judges, adding that they have upheld the decision of the electorates.
We are very happy that the Supreme Court has lived up to its billing. I'm not commenting on our judgment, Plateau alone. I'm talking about all the judgments. 7 judgments that were delivered today were all based on justice, not politics, not emotion. And we thank God for the Supreme Court.
I have no regrets in my consistent stance defending the judiciary as the weakest arm of government, because without the judiciary, we can never have a virile democracy. God bless the judiciary. God bless the Supreme Court today for its decisions that were highly pro-masses, were highly consistent, and were highly redemptive.
The Apex Court, in its unanimous judgment, reinstated governors of Kano, Zamfara, and Plateau states, which had earlier been sacked by the court.
We have our guests already seated. Barrister Obiorome, welcome to the show.
Thank you very much. I'm glad to be here once again.
Thank you. Barrister Deji Olale, welcome you to the show.
It's always a pleasure to be here. Thank you.
All right. Okay, so we'll dive into the nitty-gritty of today's topic. Of course, our first topic is the recently delivered judgment of the Supreme Court of the various appeals that came before it. Of course, up to about 6-7 states, including Lagos, Kano, Plateau State, Ebonyi, Enugu, and some other states were dispensed.
Even Ogun State.
Yes, Ogun State, yes. We are dispensed with during the week, And of course, everybody seems to applaud, the industry of the Supreme Court and the ingenuity in their decision. So what do you have to say about that?
Well, we are glad that these matters are being dealt with timeously and expeditiously this time around. Well, it's unlike what we have had in the past, where some of the matters are delayed, but for this one, I think there is a need to commend the Supreme Court for a job well done, except that there are still lapses in some of their decisions. Some of the decisions are not really in line. We can't realign it with some of the age-old decisions in respect of some of the same principles and issues that have been dealt with. But nevertheless, the fact that they have been able to dispose of these appeal, I think is worth noting. All right, commending.
All right, thank you. But these decisions of the Supreme Court, especially the recent ones, seem to have Ghana, of course, I understand that the Supreme Court doesn't decide based on public perception or public direction. But these recent decisions, we saw from what we could read and what we could hear, that even both the appellants and seem to agree with the Supreme Court, and there were no much controversies in some of these decisions. So what do you have to say? I think that is a flaw for the judiciary.
Yes, I agree entirely that the recent judgments of the Supreme Court, are in line with the expectations of people for justice. You see, across the entire country, both the winners and the losers, they all came out to applaud the Supreme Court that yes, the judgments are in tandem with fairness and justice. And when you say judgments in tandem with fairness and justice, it means that they have, aligned with previous decisions over time. Because that is the area that people kick, that you have decided this previously, why depart from that? So, yes, we commend the Supreme Court decisions of last week, Friday, Yes, because one, like my brother and colleague said, it is a clear departure from what used to be. Because I recall that in yesteryears, there was a time that it took 3 years and 8 months for the judgment between Buhari and Atiku's appeal to be decided. So 3 years and 8 months, which means that it remains just some few months for that tenure to elapse. But you know, this will have been done with dispatch. So I really commend the industry and all it has taken them to come out. And again, you see, Nigerians are once more very happy that there is hope in the judiciary.
All right, thank you very much. Talking about in line with justice and fairness, there has been an outcry in Plateau State. If you recall, about 23 lawmakers, representing both the federal and the state lawmakers elected under the platform of the People's Democratic Party, were sacked on November 23 by a 3-man panel of the appeal court sitting in Abuja, based on issue bordering on pre-election matter, that they were not validly nominated by their party, that their mode of nomination was not in accordance with the constitution or with the constitution of their party, as the case may be. Even the Plateau State governor was even sacked by this same appeal. Then, coming from the decision of the Supreme Court, it is no longer hearsay. It is a fact that that decision was perverse, as has been re-echoed by the Supreme Court. But the issue is that the justice and fairness, the people of Plateau State seem to be crying to the high heaven as it stands now for justice and fairness. But of course, we know that the issue parliamentary election terminates at the appeal court, given that they are the final arbiter when it comes to this. So people have clamored, is there no remedy? What should be done? How can would these lawmakers who have been unjustly sacked and the mandate of the people that were freely given to them robbed by the Court of Appeal, what happens to them? Mr. Deji, so what happens to them?
This is one of the travesty of our electoral system, and particularly the judicial determination of election matters. It's unfortunate that this is happening at this time. Just as you have rightly observed, the highest court for the purposes of election petition matters to the legislature is actually the Court of Appeal. And by virtue of that, the decision that have been handed down by the Court of Appeal will appear to still stand. But unfortunately, if you look at the decision of the Supreme Court, one cannot, if you look at it, you will discover that it has more or less annulled the fabric, the basis upon which that judgment of the Court of Appeal was given. So one can impliedly say that that judgment is no longer standing. Even though it is true that the Court of Appeal is still the highest Court of Appeal for the purposes of election. But the question is, what procedure, what method, what mechanism or remedies are there for these legislatures? Because unlike the Supreme Court, where you can make an application for remedial orders, in the case of the Court of Appeal, there is no such provision, either in the Court of Appeal or in the amended rules, that allows them to be the highest court in respect of those matters. So obviously, it's going to be difficult for those legislators to take any legal step. But for political step, maybe for political purpose, it may be that the decision of the Supreme Court, being the highest court of the land, can be pointed out as the overall decision in respect of this matter. And since that decision is contrary to the decision of the Court of Appeal, it means the Court of Appeal decision has been determined by a Kurian. So I don't think there will be any objection, legally speaking, by anyone if the process, the electoral machinery, sorry, the political machinery takes its course by those people returning back to the house on the strength of the Supreme Court judgment. If you understand what I'm saying. What I'm saying is that by implication, the Supreme Court judgment has rendered the judgment of the Court of Appeal per incuriam. And to that extent, that judgment can no longer subsist.
Per incuriam.
Yes.
Can you give us, enlighten us on what you mean by that?
Now that is where a court has made a decision without advertence to principles of a higher court in respect of the same matter. Now there have been plethora of decisions on where the Supreme Court have said that matters that are pre-election matters are not to be basis for election petition. So, and if a pre-election matter, if a judgment is based on a pre-election matter, as if it's an election in an election petition, it means that that decision is taken without advertise to the decisions, plethora decisions of the appellate court, and that decision is per incuriam. It means it's invalid.
It's null and void.
Yes, strictly speaking.
Okay, I think that would be a good news to the lawmakers in Plateau States if they are watching this program. So, Vice what do you have to say? Because you have made a heavy weather on the issue of justice and fairness. Obviously, the justice of this case was not properly dispensed. Has been even lamented by the Supreme Court. In fact, they went ahead to condemn those judgments and berated those appeal court judges who took those decisions, because they said that they had on several occasions given judgment on the issue of pre-election matters. So there is no basis for them to have gone outside that.
Yes. The case is clearly one that, like the Supreme Court at least said, it is a clear miscarriage of justice. First, what the other party, the APC, contested, took to court, was the issue that the Supreme Court has since decided falls within the purview of the internal affairs of the political party, the PDP. The Supreme Court has said in a number of cases that those matters that are the internal affairs of a particular political party are not to be challenged by the other parties. That the Supreme Court has said as far back as 1983, in the case of Ono and Okafor, that internal affairs of political parties should not be the subject of litigation by the other political parties. That is one point. Secondly, the issue they took to court, which the Court of Appeal finally decided, was a pre-election matter. So, the question now is, what is the remedy? What is the way forward for the victims of the apparent injustice? We know that there are 2 senators of PDP extraction, and then 3 members of the House of National House of Representatives, and 11 members of the State House of Assembly that are victims of this apparent injustice. Now, looking at it, the Electoral Act says that election petitions must be concluded within 180 days. And appeals must be concluded within 60 days. 180 days gone, 60 days gone. And again, by the Electoral Act, the Court of Appeal is made the final court in respect of election petitions relating to legislatures, both the National Assembly, House of Representatives, National Assembly, and the State House of Assembly. And that has vindicated our position. I've been saying, in this platform, that we need to go back to drawing board and take steps that will ensure that there are no injustices in the system. And what are those things I have been advocating? That all electoral matters, appeals relating thereto, be taken out to the Supreme Court. This is a vindication. And why is it a vindication? Because the Supreme Court has, by virtue of the fact that it has the final court for governmental election for the governors, has taken time to address the judgment of the Court of Appeal for the governor. And the Supreme Court has said that that was a perverse judgment. And the governor has benefited from that Supreme Court judgment. But you see, a lot of lawyers, commentators are saying that since the Court of Appeal is the final court for legislative appeals, that there appears to be no remedy. That is the contention of some of the lawyers. That, well, it's unfortunate that they have to bear the brunt of a system that they did not impose on themselves. But personally, I believe that this is a pointer to the fact that there must be a change in a Constitution and Electoral Act, and like we've also recommended, let elections be conducted a year before the handover period, so that there will be enough time for the election petitions and the appeals relating thereto to be taken, so that at the end of the day, even before swearing of the elected officers, let all the appeals be terminated and at the Supreme Court. I've also advocated that we can have other divisions of the Supreme Court. Then coming to the remedy, because what we are looking at is what is the remedy of these, yes, victims. Now, I believe that the law is not an ass. And even if the law is an ass, the late F.R.A. Williams said that there must be a limit to the acidity of the law. And what does that portend? Justice is the very essence of law. To have justice. And then we have a case in our hands where there is apparent injustice. Then my own view is that by the principle of AB jus, AB remedy, where there is a right, there must be a remedy. There has to be a way of restoring to the victims of the apparent injustice the seats that were snatched from them. And how will that be done? My own approach is that they need to go for the interpretation of the Supreme Court judgment as it relates to them. They are not filing appeals because the period for appeals are already over since. They are not filing fresh matters. All they want to do is to go to the court to ask the court to interpret the judgment of the Supreme Court delivered last Friday vis-a-vis their position and the judgment of the Court of Appeal. Because, you see, the eyes of law and equity will not be close to injustice. They will not allow them to just go there and be crying that they've been robbed of their mandate. Because who are the people that have been affected? The electorates, the masses that have decided the people that will be their candidates, the people that they've voted into power. They are victims. Also, the people that have been voted into, various positions, but because a matter was taken to a court, a matter which that court ought not have taken, and the court took it and gave judgment, which the Supreme Court finally reversed as far as the governor is concerned. Justice will not allow that. I recall that in one of the judgments of the reverse master of the rolls, the Lord Denning, he had cause to say that the law can never be stagnant. Because the society is dynamic, society is moving everything, and the law cannot afford to be stagnant. And that if there is a right, by all means there must be a remedy. And that if there has not been a precedent in a matter of that nature, he had a duty as a judge to create one. And that if in doing so he will be damned, he will be called, he will be termed an activist judge, he will plead guilty to the charge. What am I saying? That it is necessary for our judges, the courts, to allow the toga of formalism to be buried. Because you remember that Justice said that even though the forms and all these have since been buried, but they still room for the graves. We should come out and ensure that we make that justice. And what is justice? What is in accord? One, with reality, with what people regard as fairness. People have been elected, and Supreme Court has said that what was used to remove them was wrong. Will you now allow them to go and be cried day in, day out? The answer is no. Well, of course, I'm also aware from what the papers have said that PDP is contemplating writing a petition to the NJC on the matter. But what will NJC do? NJC cannot, as a body, come out to overrule the decision of a court that is still valid and subsisting. Because the whole appeal judgment has not been but like I suggested, the proper thing is let there be interpretation, and it's that interpretation that will now clear the road for them. Yes, on a calm, objective analysis and view of the decision of the Supreme Court in respect of this, because the same complaint, the same issues that were decided, that what is to be done is for them to go and occupy their seats, because by the Supreme Court judgments, the very fabric, the backbone, the reason for the decision of the Court of Appeal in their matter has been knocked out and nothing left.
Yeah, but since we are not parties to the decision, doesn't it affect this thing? I'm sure the Supreme Court have said that they are not Father Christmas, so they can't, of course.
No, what I've said is that is why there will be need for them to approach the courts to review the Supreme Court decision vis-a-vis that of the Court of Appeal as it relates to them.
Yeah, but the appeal court, do they have, since the appeal court is the final court for them, does the Supreme Court have jurisdiction to even entertain their matter?
They are approaching the court to review, and my own take is that they approach the Supreme Court because Supreme Court that has given the judgment that people have applauded as oozing out justice, and then asking the Supreme Court that in view of its decision in respect of the governorship election of Plateau State, what is their fate, since it has that the judgment they have nullified for the governor is the same thing that has chained them down, and the Supreme Court will do something about it. And what will the Supreme Court do? To interpret its judgment vis-a-vis that of the Court of Appeal, and that is that. They are not going on appeal per se, because if you go by the Electoral Act, they cannot appeal on it because that's the last court. But they can ask the court to, just like what used to happen, that sometimes you may take out an issue for interpretation.
Okay, but okay, let me, Barrister Deji. Yes, Barrister, you have hammered more on this issue of all cases even getting to the Supreme Court.
Yes.
But shouldn't we have confidence in the Court of Appeal, given the fact that even the Supreme Court judges emanated from the Court of Appeal, before they got to that place? So shouldn't we have faith and trust that at least the simple principles of law would be followed by the Court of Appeal?
Let me first of all just comment about what my good friend just said about interpretation. I do agree that that's the proper way to go. But the only problem is that the Supreme Court will not have jurisdiction to even take that application. The Supreme Court will not have the jurisdiction because there is no nexus, and those persons that they have no local standard to even bring any application before the Supreme Court, because that would be an originating application, and the only court that has the power to bring originating application before the Supreme Court is a state, only a state. So I think the best way to go, I said something earlier on, I agree that they can interpret, but the court that should properly interpret his own decision is that Court of Appeal itself. Because by virtue of, I said earlier on that the decision of the Supreme Court has rendered their judgment par incuriam. What those parties, those legislators ought to do is, in the light of that Supreme Court decision, file an application before the Court of Appeal to set aside that judgment on the grounds that it was given par incuriam. And they will now to make advertence to all the Supreme Court decisions that have decided the issue of pre-election matters and post-election matters. What can constitute post-election matters? It is true that my good friend, as he has said, the internal democracy of parties does not allow for any other person to raise issues that relates to questions of nomination by a party, the candidacy of a party. All right, there have been so many cases of that. So the proper court that should hear it is the Court of Appeal itself. And I also want to say that as the Court of Appeal, that Court of Appeal is sitting as the highest court of the land. By virtue of that order, it means that he is sitting as Supreme Court for the purpose of those set of cases under which it has been given jurisdiction. So the order, the law, the Supreme Court Act, will apply to the Court of Appeal for the purpose of those election matters.
Yeah, but
and one of the provisions of the Supreme Court Act, under Section 20 of the Supreme Court Act, the Supreme Court can review its own decision
on the same matter.
Okay. So the Court of Appeal cannot do that if it's hearing any other appeal, because it's not the highest court, it's not the apex court. But since it has been made the apex court by virtue of law, then it means it's sitting as Supreme Court for the purpose of those election matters. So they can review their own decision.
Well,
so that's the way to go.
I agree with my brother, to the extent that yes, there must be a solution.
There is a solution.
There has to be, and the solution is the review. The only area I want us to look more closely is the judgment of the Court of Appeal that has been delivered. The judgment of the Court of Appeal is already frontus official. It cannot sit on appeal over its own judgment.
No, it's not an appeal. It's
No,
not
no, yes. It cannot, go to start reviewing, because you see, when you are reviewing, you are trying to set aside. It cannot. Once the Court of Appeal has decided, it has decided.
That is,
now it is only the now it's only
if
the
it's sitting as a Supreme Court.
Now. Can we now say that? Can we now say that Court of Appeal can set aside? Can we now say that?
Even if they discover that their judgment is in par incuriam.
Can we say that Court of Appeal can metamorphose into Supreme Court?
Yes, by legal implication. That's the position of the law. If
that's the final court, but that doesn't translate it to Supreme Court, and cannot use Supreme Court rules and
no.
It cannot. What I believe is the way to go is to approach the Supreme Court ex debito justitia, that in the interest of justice, you understand, it is not just an individual that is affected. 2 senators,
but 23 lawmakers.
Then 3 members of House of Representatives and 11 members of the State House Assembly. So I believe that the proper forum is the Supreme Court.
Well,
the Supreme Court has
the succeed if they go to Supreme Court. Because the Supreme Court will have to first of all look at it. Wonder what basis would they review that judgment? Since that court is rendered the highest court for the purpose of that kind of cases.
Would
they sit on appeal over a court that is deemed to be equivalent to them in concurrence of jurisdiction as regard that issue.
Wait, you see, look at it this way.
That's the issue now.
Look at it this way. The Supreme Court has given a judgment last Friday.
Yes.
And the judgment given by Supreme Court is on the same complaint, the same issues, the same fact, no difference.
But they are not.
And the Supreme Court has come to say
court in respect of that matter.
The Supreme Court has come out to say that what has happened at the Court of Appeal was a perversion of justice, a miscarriage of justice, and lambasted the Court of Appeal. Now, the issue is if a application is brought to the Supreme Court.
Under what law? Under what rule? For what basis?
Now, to review.
How?
To review to look at its judgment. To interpret it vis-a-vis the decision of the Court of Appeal. They do.
That's the implication. That's the implication of the law that makes them. That doesn't mean the highest court for the purpose of election petition. For that purpose, under the law, there is Supreme Court on that basis.
No. You see, let's look at it. See it this way. If Supreme Court is on the same pedestal, the same level with Court of Appeal, Supreme Court wouldn't have had the audacity to lambast the Court of Appeal on that judgment and damn it, perverse judgment, miscarriage of justice. They are not on the same level. We know that. We're only saying that because of the structure we have, that to avoid overburdening the Supreme Court, let some appeals terminate. That doesn't make them to be at bar. And remember,
the point that the issue is, please let me make this point very clear. And they can try, if they try it, they will see the consequence of what I'm saying. Notwithstanding that the Supreme Court lambasted, the Supreme Court is talking as the highest court for the purpose of election.
So you now agree it's the highest court, now not the same level.
I agree that. I agree that that's in the one that they have jurisdiction, which is governorship election. But if it has to be an application coming from the Court of Appeal, in respect of which the Court of Appeal has the highest and the apex jurisdiction, the implication of that is that whatever decision they give will be par incuriam also. Because you are now trying to set aside the decision of a court that has a concurrent jurisdiction with you on that same, on the issue of legislators, the determination of the matters of the legislature. So the proper thing they should do, that Court of Appeal that gave that judgment, they can apply to that Court of Appeal to set aside this judgment as giving par incuriam in the light of the Supreme Court judgment, not.
You see.
Not in the sense of.
You say if you toe that line, you still come to the same jigsaw of one. Court of Appeal, by its act and rules, cannot review its judgment on decision. It's only the Supreme Court that can do that.
That's another error. It is true that Court of Appeal cannot set aside or review.
It's Santos official.
If it is acting as a Court of Appeal. But in this case, it's not acting as Court of Appeal. Even though it's Court of Appeal, it's acting as the Supreme Court, the highest court, for the purpose of that election petition. So at that point, the implication is that it is the highest court, is the Supreme Court for the purpose of that, of those elections.
All right. Thank
you. That's my view about it. Anyway.
Thank you, Barrister Deji. Of course, there are no. Every issue must always have a remedy. We are in agreement that there should be a remedy.
There should be. Obviously, there should be.
Lawmakers that have
going to Supreme Court or Court of Appeal
unjustly removed and their mandate taken away from them. Of course, the way or the means during which this
the
modalities seem to differ. Of course, Barrister Deji has advocated that they go through the appeal court since they are sitting as the highest court for that case, while Barrister Obiora is of the opinion that the Supreme Court should be approached for interpretation of their judgment
vis-a-vis the Court of Appeal decision, since it's the same thing. Yes.
Of course, if these lawmakers are watching, of course, the two options are viable options that they could employ, because the legal maxim ubi jus ubi remedi applies to their case. At this juncture, we'll go.
That has a right, it must be.
And when we return, we'll take the second topic for today. Stay tuned, don't go anywhere.